Good morning and welcome to the fourth installment of the Kenny and Sam's Construction Law webinar series. I'm here with my partner Nate Cole, and we're going to be talking to you today about liquidated damages, comparison to consequential damages. As part of the program, we're not only going to give you an overview on how liquidated damages work under the law, but how to negotiate them on the right project, why they may be better than consequential damages. Risk transfer mechanisms in your contracts and subcontracts so you can pass along any risk you may be taking on to the extent there's a tier under you that you can pass the risk of liquidated damages on to. And last, we'll go over some defense options in the event that you are down the road ever faced with an assessment of liquidated damages. Now, before I flip it over to Nate, just a couple housekeeping issues. If you've got questions, feel free to send them. We will either take them during the program or if we're running out of time, because we really do want to be able to get you out of here by in 30 minutes, so by 8 o'clock. We'll have a record and we'll be happy to follow up with you to answer any questions. And just for purposes of schedule, note that our next seminar program will be on October 21, and we're going to be dealing with prompt pay at that time, and we'll get you more information on that in the meantime. But with that, let me flip it over to my partner Nate Cole to give you an overview on liquidated damages under the law.
Sure. Thanks, Mike. Good morning, everyone. So before we get into the specifics of liquidated damages, I think it's important to just consider contract damages generally. So contract damages generally are typically about proving actual damages. And in contract law in Massachusetts and throughout the country, what the courts look to is whether a party who has been aggrieved or been injured in the event of a breach is compensated. We refer to that as compensatory damages, as compared to punitive damages, which are meant to punish. So liquidated damages provisions or payment for breach provisions have to comply with that general concept that contract damages should be compensatory and not punitive. Well, in many instances, the party that's aggrieved, rather than go through the steps of trying to prove actual damages, and Mike will speak to the difficulties in both construction contracts and contracts broadly with proving actual damages, the expenses that can be involved, the use of experts, and frankly, additional time with lawyers, why it makes sense for parties to instead focus on agreeing up front as part of the negotiation process on a payment for breach provision, liquidated damages or LD provision. You may think that just because you have an LD's provision in your contract that it's going to be enforced by the courts. And that's not necessarily the case. So all LD provisions are simply not created equal. And in the event that one of the parties where there's a breach is trying to challenge the LD provision, the courts are going to step in and they're going to look and evaluate the processes by which the parties got to the LD provision, the facts of surrounding the LD provision, and ultimately they're going to evaluate whether the payment for breach or liquidated damages provision is bona fide, is legitimate, in which case the courts will find that it's enforceable, or whether the courts are going to determine that that LD provision is in fact a penalty, is more punitive, and in that instance would not be enforced. Why does that matter? Well, it's fairly significant if the parties are in a contract and believe they've got an LD's provision, and a court steps in and says, no, not so fast, that's a punitive penalty provision, we're not going to enforce it. Now they're stuck having to prove actual damages, and as we just discussed, that's expensive and it's a mess. So what do courts look at when they're evaluating whether an LD's provision is in fact bona fide or enforceable, and whether the party challenging it is going to be told they're wrong and it's going to be honored by the court? Well, the courts do look at the party's intent. In fact, the case law in Massachusetts talks about the courts giving considerable deference to the parties, both in contracts broadly, but with LD provisions specifically. The same language, however, in the Mass decisions talks about that considerable deference given to the party's intent not being unlimited. By that I mean, while the courts will look at the intent, they will consider it, and in fact give it a fair amount of leeway, ultimately the courts are going to look at the circumstances surrounding the negotiation of the contract, surrounding the liquidated damages, before the courts make the decision as a matter of law that that LD provision is either bona fide and enforceable or is unenforceable, is a penalty, and they'll make you prove actual damages. We'll talk a little bit more about the party's intent and how you want to memorialize it, because as much as it's not dispositive or is not the only thing that the courts are going to look at, we do think it's important that you include the party's intent and memorialize that in the contract. We'll talk about how to do that in a moment. What the courts do in Massachusetts is conduct essentially a two-part test. And this is important that you think about this two-part test as not an either or, but a both. That is, you have to establish both of these parts of the two-part test for a court to find that the LD provision is enforceable. The first part of the two-part test that the courts will look to is whether at the time of contract formation, and that's important. We're looking at the time the contract was formed and executed, not later when the breach occurs, but at the time of contract formation, the courts will look to see whether the amount of the liquidated damages would have been difficult to estimate. The actual damages would have been difficult to estimate at that time. If the court finds that the damages to the aggrieved or injured party would have been difficult to estimate, then that's going to meet the first part of the two-part test. You're not out of the woods, however, at that point, because the second part of the test, the courts will then look, again at the time of contract formation, as to whether the liquidated amount, the damages amount set forth in the contract, whether that is a reasonable estimate of what those compensatory damages would have looked like. Okay, so again, it's worth repeating, two-part test. The first is at the time of the contract formation, is that liquidated amount something that would be difficult to attain, estimate rather, in terms of actual damages? And second part, whether that amount is a reasonable estimate of the actual damages. Those are two distinct tests, and again, you have to meet both of them, but there is interplay between those two. And by that I mean, the more difficult it is to estimate the actual damages, the more likely a court is to find that the LD amount is reasonable. So there is the back and forth between the two. I think it's helpful to sort of think of this in a simple example that I can give. We'll talk about it to make the point of these two factors. You've got an athlete that signs an endorsement deal with a manufacturer of shoes. And under the terms of that endorsement deal, the athlete has to wear the shoes to all red carpet events for a 5-year period. Within that agreement, there is a liquidated damages provision, the payment for breach provision, that says in the event of breach, the athlete will have to pay $5 million for a liquidated amount. Athlete goes, and over the first 4.5 years of this contract period, wears the manufacturer's shoes to all events. They're highly televised, lots of publicity. Right at the end of the 5-year deal, however, the athlete shows up to a small event, doesn't have the manufacturer's shoes, has a competitor's shoes on it. There aren't cameras, but somebody in the crowd catches the athlete on Instagram. It pops up. Athlete gets sued. Manufacturer says, I've got you dead to rights. You owe $5 million pursuant to the contract. I'll turn to Mike. Mike, enforceable or unenforceable LD's provision? What's your take?
I'm going to give the lawyers very qualified, potentially yes. It seems to strike me as falling right into that area where liquidated damages would be appropriate. We need to know a little bit more information concerning what the parties knew at the time they were negotiating. But yeah, it does strike me as one of those scenarios that meets the two-part test.
It's not often, but I think Mike might be wrong, and if I were going head-to-head with Mike, I wouldn't want that. But I may push back, and here's why I'd push back and say that, in fact, it would not be enforceable, and it is a penalty. First off, with that first part test, I do think that the manufacturer and the court would look at that and say, boy, those damages are really difficult to estimate. How on earth are you supposed to say, in the event of a breach of that sort of an endorsement deal, what the damages would look like to the manufacturer? So I think they probably satisfy part one. Where I think the court may have a real difficult time with that particular provision, however, is in part two. Because how are you going to say that at the time of contract formation that a $5 million hit would be a reasonable and fair estimate of those damages? The athlete goes to 50 events, they're highly televised, they've worn the manufacturer's shoes, and on one little event at the very end, doesn't wear them. I don't know that $5 million is a reasonable estimate at the time of contract formation. What's a notable point about that, and where I think Mike probably would have the advantage, is that if you're challenging LDs, then you have the legal burden of proof. And so if you're the manufacturer, you're saying, look at the contract, Your Honor. It says in the contract that this is a $5 million LD's provision. We couldn't figure out what that amount would look like. this is exactly what LDs in a contract are for. So I think it would have an uphill battle, but Massachusetts courts in that type of situation could very well decide to strike the provision and then force the manufacturer to prove actual damages.
Can I jump in for
Of
1
course.
second, since you've attacked my ability to be right here? I would just throw in one of the things that a court may look at, and this is sort of an amorphous piece, but courts in some of these LDs cases have looked at it, and they've said not only was the amount of the damages, the actual damages, tough to forecast at the time the parties signed the contract, but you had two sophisticated parties entering into an agreement here. So, in the construction context, you've got businesses contracting. A lot of times you have lawyers representing the businesses, negotiating the contracts. So you do have that scenario where you've got sophisticated parties entering into it, which makes it a lot harder for the court to say, I'm going to undo what these sophisticated parties agreed to. In your scenario, you'd have a situation where you've got this probably very wealthy athlete represented by a business manager and lawyers. It gives you an additional overlay piece that makes it less likely, in my view, that the court would throw it out. But and I know you're going to get into this, there's also language issues that can come into play in terms of the exact language that's used to enforce the liquidated damages provision in the contract.
Sure. So I think, to steal Mike's point earlier, it depends, right? And I mentioned that ultimately the courts are going to look at the circumstances of each case. Mike pointed to some drafting considerations that I want to turn to now. As much as we say that the intent is not dispositive or doesn't answer the ultimate question, it certainly is something that's helpful in the contract. And so for drafting considerations, what you want to see in a contract when it comes to the payment for breach LD provision is language that says, first off, the parties recognize and agree that it would be difficult to estimate the actual damages in the event of breach. So that language in a contract is helpful.
Excuse me real quick. That is especially if you're the one who is later going to be the one enforcing the LDs.
That's right. I think if you ultimately want those LDs, you really want to push on that language and have the other side agree at the time of contract formation, and they're signing it, that it would be difficult to estimate. You also want to have the language for part 2 of that test, which establishes that this number that you're seeing in the contract for LDs is a reasonable estimate of what those damages would have looked like. So as much as the intent doesn't matter, I think it's impossible for a court to look at a well-drafted contract in which two parties, in particular sophisticated business entities, are agreeing at the time of formation that essentially this LD provision satisfies both parts of the test. So that's really helpful language to have in there. You obviously want to stay away from anything in a contract, an LD provision, that talks about it being a penalty or punitive. I think you want to stay away from anything that talks about language that would suggest that actual damages would be easily ascertained. And you similarly want to make sure that you don't have anything that suggests that LD amount is greater than actual damages.
And again, those cautions are with respect to the party who would want to be enforcing the LDs. If you're somebody who is taking on the risk of LDs, you may not dislike that language ending up in the contract, because they're going to give your lawyers a hook towards fighting back down the road and arguing to a court that the LDs are unenforceable because, in fact, they're a penalty and therefore unenforceable as a matter of law.
Yeah, that's a key distinction. It really depends on which side of this you're coming at it from. But just understanding these are the sorts of issues that are going to play out when a court is called upon to interpret that provision and ultimately decide whether it's an enforceable, bona fide liquidated damages provision or whether it is, in fact, a penalty that was in no way related to what the damages looked like at the time of contract formation. So I'm going to turn it over to Mike, who's going to jump into the specific LDs in the context of construction contracts and some risk management advice.
Thanks,
Mike?
Nate. Thanks. So, we're all of us, when we hear LDs as a potential in a contract that may be forced upon our clients, our natural reaction is, whoa, let's keep those out. But there's some scenarios where LDs are the better of the choice. So let me start with, if you have a contract where you're very comfortable with the construction schedule, it's doable, you've got good change order language, so you have some flexibility with regard to getting additional time that'll safeguard you against the assessment of liquidated damages in the future. It could be a scenario where LDs are acceptable. You've got good profit, so you've got good profit, good schedule, and good change order language to start with. If on top of that, you also have the owner agreeing to waive consequential damages, and I'll talk about those in a second, but you have the owner agreeing to waive consequential damages. In other words, the damages it's going to incur if you're late. But the owner is saying, look, I'll do that only if we can come to some sort of agreement on liquidated damages. Then in those circumstances, it may be beneficial for you. That is, assuming it's, you've got good profit built into your contract and you want to do this job. Here's why. If an owner is in a situation where it's waived consequential damages and it cannot recover liquidated damages, then it is in all likelihood going to be precluded from recovering any delay damages. And that's because consequential damages are the damages that come from delay. Here's some standard language that you'll see in an AIA 201. It comes in section 15 of that form contract. And I'm just going to read it to you for a second and then talk about it. The contractor and owner waive claims against each other for consequential damages arising out of or relating to this contract. The mutual waiver includes damages incurred by the owner for rental expenses, for loss of use, income, profit, financing, business and reputation, and for loss of management or employee productivity or of the services of such persons. In other words, with the waiver of consequential damages, owners giving up potentially all of its damages incurred for delay. So you are going to encounter situations where the owner says, okay, that's pretty standard. In fact, if we're advising you, I would say don't enter into a contract where the owner is refusing to waive consequential damages, because the enormity of those damages is so much that it can sink your company. You shouldn't be entering into a contract for construction without a waiver of consequential damages. But if you've got a sophisticated owner on the other side, they're going to come back and say, well, I need something if you're going to be late. I need some way to recover some damages. And in those scenarios, again, assuming you're comfortable with the schedule, you've got good change order language that you're comfortable with, you're good with the profit numbers on the contract, and the owner's saying, I need LDs. It's better than consequentials, because assuming you can get to the right number, you can quantify what your downside risk is. You can't with consequential damages. Again, they could end up being $10, they could end up being $20 million that sinks your company. With LDs, you can quantify what they are by agreeing on what the dollar per day for late completion is going to be. But there's a way to negotiate it. And I go through, when I'm negotiating it, I'll usually go through a several step process. The first is what I call the kumbaya speech. I reach out to the opposing counsel for the owner and I encourage them to get rid of the LDs, because LDs do have some negative side effect. That is, they encourage owners to be maybe more strict than they otherwise would be in giving you additional time pursuant to a change order request, because they know if they're giving you additional time, they're handcuffing their future ability to enforce the LDs, to recover LDs. So they tend to fight more on requests for additional time. And so my kumbaya speech is, look, we're partnering here. Having LDs just encourages fighting later on, and the fighting on schedule is going to spill over into fights on other things, and we're going to have a catastrophe on the job. Let's work together on this. Let's be together on this. Doesn't always work. Sometimes it does, sometimes it doesn't. The next step in the negotiation process is to say, just using some logic. Well, okay, if you're really going to be hurt here for every day my client is late finishing the job, well, the flip side of that is you're going to benefit for every day that my client finishes early. In which case, if you think the damages per day is reasonable at $1,000 a day or whatever the number is, my client should get a corresponding bonus for every day that it finishes early. Now, sometimes owners will just say no. And you say, why? And they say, because I'm the owner. I'm not going to do that. I'm not giving you a bonus for finishing early. You're getting paid under your contract to finish on time. And if you finish early, that's great. But I'm not going to pay you for it. Other times, the effect will be that the logic prevails and the owner will say, all right, well, I get it. We'll give you a bonus, but let's reduce the numbers. Instead of it being $1,000 a day in LDs, it's going to be $500 a day and you'll get a $500 bonus. Or can we agree that you get only a $250 a day bonus. In any event, we've now accomplished something here. We've reduced the LDs and we've given you an upside. Sometimes that doesn't work either, and you need maybe you get a combination of a lower bonus if you finish early and or a grace period at least before the LDs can be enforced. So you're pushing back and the owner comes back and says, okay, I get it. I don't want your client at unnecessary risk here in order to do this job. So we need to have the LDs. We'll give you a grace period though. So we won't, the LDs are going to be $750 a day, but we're not going to enforce them until we're at least 30 days beyond the substantial completion date. And so these are all a phasing of the negotiation to try to control the liquidated damages. But again, as much as we all recoil at the thought of liquidated damages initially, if everything else is right in the contract and faced with you got to get LDs or you're going to get consequentials, you're much better off doing LDs than you are consequentials. We wouldn't advise anyone entering into a contract without a waiver of the consequential damages. So with that, on the negotiation end, let's talk about risk transfer. So if you're the general contractor or you're a sub with sub-subs, there's a way to transfer the liquidated damage risk, and it comes in a couple different steps. One is you should have incorporation clause in your contract, and that's the language that says you're incorporating in your subcontract the language of the general contract and incorporating the general contract terms and conditions to the extent they apply to the work of the subcontractor. There's nothing nefarious about that. To the extent that you're not self-performing, that you've got subs performing the work for you, they should be taking on the risk. On the flip side, if you're a sub, it's one of many reasons why if you have incorporation language in the subcontract, you're going to want to say to the general contractor, okay, potentially this is acceptable to me, but you got to give me your general contract so I can see what the risk is that I'm taking on. But okay, going back to the risk transfer. One, you want to have an incorporation clause in your contract with the tier below you, whether it's your subcontractor or if you're a sub, your subcontractor. You also want to have in your contract payment provision language where you can hold back payment to the extent you're at risk of damages down the road. And this is standard language you'll see in an AIA. It basically says, you know, we have the right to decline payment to you down the road, or to lessen the payment, to hit you with a holdback or a back charge based on damages or potential damages we are being faced with. Of course, one of those damages or future damages could be an assessment of liquidated damages if you think that sub is behind. So that's another way that you can transfer that risk of the assessment of LDs. Last, depending on the breadth of your indemnification language in your subcontract or your sub-subcontract if you're a sub, you can pass on any LDs through that indemnification language. So those are all ways to manage that risk down to the tier below you. I'll say this though, that with respect to payment holdback, if it's a prompt pay job, so a private job, $3 million or more, you need to follow the prompt pay requirements and timely reject and explain why it is that that you're rejecting. And if you're using the threat of liquidated damages, you would say, you know, you've billed me $100 here based on where you're at on the project you're behind, and based on the liquidated damages provision that applies, we get to assess $250 a day. Therefore, based on that, there's actually no amount due, and then you certify it as having been made in good faith. But it's important you follow the prompt pay process in setting forth that holdback. So now let's talk about how we defend against liquidated damages down the road. You think you've timely completed. Owner says you're not timely. You're beyond the original contractual substantial completion date. You think you've got reasons for that. Let's talk about that a little bit, Nate, and how we deal with defending against the assessment of LDs in that circumstance.
Sure. So, I think practically speaking, I know we have some lawyers that join us and watch this as well, but I do think it's important from the outset that when you're negotiating the contract, that you actually make some effort with the other side to try to determine what the actual damages would be in the event of breach. You have to go through that exercise. And so you want to reach out to the other side. You want to have been able to demonstrate down the road. If you're being deposed and someone's pushing back on exactly what was done at the time of contract formation, you want to be able to say that we had this conversation, we made an effort, we tried to estimate. It was really difficult to do that, and be able to show what efforts were made. So if you're representing somebody in drafting one of these contracts, I certainly push my clients to explain how is it that you can't arrive at actual compensatory damages and why you need LDs, and to have gone through that process. Why? Because I think if you're being deposed down the road, someone asks those questions, you have to be in a position to be able to say, we did make this good faith effort. We couldn't arrive at those or determine what those actual damages look like, and therefore we came to this number with this LD provision that's bona fide, it's legitimate, and we all agreed to that.
So that's a great first step. So that deals with, that is providing evidence that in fact what we have here is not a penalty. We're satisfying the legal process to make the provision enforceable. If you're on the other side, you're going to want to attack and try to demonstrate that there was no effort really made, that despite the language in the contract, it really is just a penalty here. But let's assume that the language is enforceable. There's some other attacks that can be made on the assessment of liquidated damages. One is under Massachusetts case law, if you can establish that the owner or the owner's representatives, its architect or engineer, whoever's running the job, maybe even an OPM, are a cause of the delay, then you have an argument that the liquidated damages are not enforceable. Despite what the contract says, you're saying the owner and his representatives caused the delay. In that circumstance, there's case law out there that says the LDs should not be enforceable. Sort of a derivative of that argument is we're entitled to a change order for additional time. Under our contract language, we're entitled to a change order, for instance, for force majeure or for supply chain disruption. And these are all things you should be thinking about when you're negotiating the contract, looking at that language that would entitle you to a change order. If you can establish that you're entitled to a change order under the contract, then even though you came in after substantial completion, as specified in the contract, that substantial completion time should be extended, you'll have a defense to the LDs in that way. But again, when you're assessing that, it's really important that that your contract language be good, right? And that's something you should be working on up front when you're negotiating the contract. But also, it's important that you follow the contract claims process. Most of the contracts say that to make a claim for time, you have to do it in the same way you'd make a claim for cost, whatever that is in your contract. But typically, it'll say you've got to make the claim within a certain period of time. You've got to make it in writing. Email's probably just fine. But you need to do it you need to do it in a way that the contract says you need to do it. Otherwise, there's some case law out there that says potentially you've waived your claim. There's lots of arguments you could make against that, but you're putting yourself in a compromised position, especially when the threat is liquidated damages. Follow the contract, make your claims for time to extend the contract. If the owner doesn't agree, at least you're making your claim and you're reserving your rights to the additional time under the contract, because that's going to be a future attack against the assessment of liquidated damages. Another part of this is that the liquidated damages assessment is usually based on so many different things that happen during the job that you guys deal with day in, day out. There's 10, 15, 20 different things that potentially impact the critical path or don't impact the critical path. And you're going to want to work with your lawyer to come up with factual defenses to show why it is what you're saying really does affect the critical path. Doing that is going to force the owner to have to do the same thing, and hopefully it will make the owner get reasonable with the way that they're approaching the liquidated damages, such that you can reach some sort of resolution that has a better net benefit for you.
Two other quick pointers. We're mindful that we're about to wrap up here, hitting the 30-minute mark, but when you're negotiating contracts, liquidated damages provisions do not take the place of attorney's fees. So it's very important that you have an attorney's fees provision, which we push for in contracts, that would compensate you for those fees, which are separate and apart from liquidated damages. The other point I want to make is Choice of law provisions in contracts that say which law will govern. I think sometimes people overlook it and don't think it matters. But what we're talking about today is Massachusetts specific. Some other states have similar approaches towards LDs, but you really want to have a choice of law provision that specifies Massachusetts because these rules change when you go into other jurisdictions.
So just to close out, please put on your calendar October 21 at 7:30. We'll be coming back to you to talk about mastering prompt pay obligations. Thanks for joining us, and feel free to reach out if you've got any questions.